to leave, now.
What? I'm just having coffee.
Manager says you're making people uncomfortable. You're trespassing.
10 minutes ago. I'm not bothering anyone.
Are you leaving or do I need to remove you?
You're making a mistake. FBI special.
The order sounded routine. A simple request delivered with confidence inside a quiet coffee shop. No shouting, no threats, just authority, exercised without hesitation. Nothing about the moment appeared dangerous. Nothing suggested it would matter later. But it did, because that single instruction triggered a chain of records, reviews, and decisions that would not stop quietly. Internal logs were opened. Footage was preserved. Statements were taken. At the time, the officer believed he was in control. That belief would prove costly. Months later, the city would approve a payment measured in millions. Careers would not recover. Policies would be rewritten without public ceremony. This was not the result of outrage. It was the result of documentation. And it all began with one order that should never have been given. The officer stood near the entrance, positioned so the exit was no longer optional. His posture was relaxed. His voice was not raised. He did not ask for assistance. He issued a direction. The man at the table looked up, confused but calm. There was no disturbance, no complaint from staff, no visible threat. The coffee shop continued operating around them, unaware that a line had already been crossed. The order was repeated, clearer this time, more final. A moment passed where the situation could have ended without consequence. It did not. The officer referenced procedure without naming one. He spoke as if discretion alone was sufficient. The space between a lawful request and an unlawful command collapsed quietly, without spectacle. Nothing in that exchange suggested criminal intent. Nothing required escalation. Yet the decision was logged. The encounter was recorded, and from that point forward, the outcome was no longer in the officer's hands. What followed would not be resolved on the cafe floor. It would be reconstructed later, frame by frame, inside conference rooms and court filings. By the time the officer walked away, the cost had already begun accumulating, even if no one there understood it yet. The man seated in the coffee shop was not anonymous in his daily life. He lived within routine, structure, and accountability. His work required restraint, precision, and an understanding of authority that left little room for improvisation. He was trained to recognize lawful orders, to comply when appropriate, and to document when boundaries were crossed. Outside of work, his life was unremarkable by design. Early mornings, long hours, familiar places chosen for their quiet predictability. The coffee shop was one of them. A neutral space, public, open, accessible. A place selected precisely because nothing unexpected ever happened there. He had not sought attention. He had not asserted status. He had not challenged authority. At the moment the order was given, he responded the way he had been trained to respond, in countless professional settings, calmly, deliberately, without escalation. He did not argue. He did not raise his voice. He did not reach for identification unless asked. His body language remained neutral, his tone measured. There was no history of complaints tied to his presence, no prior incidents, no behavior that would later require explanation. To anyone observing closely, the imbalance was already visible. One individual operating within discipline and constraint, another exercising discretion without verification. The interaction did not hinge on resistance. It hinged on assumption. The man understood the implications of confrontation in public spaces. He understood how easily situations could be reframed after the fact. He also understood that compliance did not erase improper conduct, it merely delayed its examination. So he complied. He stood. He gathered his belongings. He did not rush. He did not linger. His departure was orderly, intentional, and documented only by cameras that never blinked. At no point did he claim victimhood. At no point did he accuse. He left knowing something had been misapplied. Not emotionally, but procedurally. The kind of error that does not announce itself immediately. The kind that only becomes visible once records are reviewed in sequence. Later, when the encounter would be reconstructed, nothing in his background would complicate the analysis. No conflicting narratives, no credibility gaps, no conduct requiring contextual excuses. The facts would stand on their own, and that mattered, because when authority is questioned, the moral standing of the person subjected to it becomes the first point of scrutiny. In this case, there would be nothing to dispute, no ambiguity to exploit, no character flaw to redirect blame. The foundation had already been set. What remained was the event itself and the moment when it crossed from discretionary judgment into something else entirely. Before the interaction, everything about the setting was unremarkable. Late morning light filtered through the windows. Conversations stayed low and indistinct. Orders were taken and filled without delay. The environment functioned exactly as it was designed, to public, neutral, and uneventful. The man had entered without incident. He waited his turn. He paid. He took a seat. No one paid him special attention because there was no reason to. His presence blended seamlessly into the routine flow of customers who came and went without leaving a trace. There were no raised voices, no complaints to management, no call for assistance. Nothing about the scene suggested the need for intervention. From a procedural standpoint, the conditions were clear. A lawful public space, no posted restrictions, no disruptive conduct, no safety concern articulated by staff or patrons. The situation, as it existed, required nothing more than observation, if even that. This was the final point at which the encounter could have ended as nothing at all. When the officer entered, the atmosphere did not change immediately. There was no tension in the room, no sudden shift in behavior. The officer surveyed the space briefly, as officers often do, without drawing attention to himself. Then he stopped, his attention fixed on one table, one individual. There was no visible trigger. No exchange preceded the focus. The decision appeared instantaneous, formed without consultation or confirmation. The officer did not approach staff first. He did not request information. He moved directly toward the man seated alone. At that moment, everything was still ordinary. The coffee had not cooled. The room had not gone silent. From the outside, the interaction that followed would appear minor. A few steps, a short sentence, a pause waiting for compliance. But that appearance masked the significance of timing, because once the officer spoke, the encounter could no longer remain informal. Authority had entered a space where it was not required. The man looked up, attentive but composed. He listened. He processed the words. He recognized the weight they carried, not because of their volume or tone, but because of who delivered them and where. This was the final, ordinary moment, the last point before the situation transformed from a routine visit into a recorded event. Nothing had yet been challenged. Nothing had yet been resisted. But the conditions had changed. From this point forward, every action would be measured against policy, law, and record. Every second would matter. And what had begun as a quiet morning would soon be examined as evidence of something far more consequential. The officer did not introduce himself. He did not explain why he was there. He began with a directive. The instruction was framed as routine, delivered with the expectation of immediate compliance. It carried no justification, only the implied weight of enforcement. When the man hesitated, not in refusal, but in clarification, the tone shifted. The officer repeated the order. This time, it was slower, more deliberate. The language tightened. What had initially sounded optional now carried consequence. The officer referenced authority without citing a violation. He spoke of policy without naming one. The ambiguity was intentional. It placed the burden of interpretation on the person receiving the command. The man responded calmly. He asked what rule he was violating. The question was reasonable. It was also unwelcome. The officer interpreted inquiry as resistance. His posture changed. He stepped closer, reducing physical space. The conversation was no longer between two individuals in a public setting. It had become a demonstration of control. The officer warned that failure to comply could result in removal. Still, no cause was articulated. The escalation was procedural, not emotional. No profanity was used. No threats were shouted. No hands were placed on weapons. Instead, authority was asserted through repetition and implication. The officer spoke as though the outcome had already been decided. Each sentence narrowed the options available: compliance or consequence, departure or detention. The man recognized the pattern. He had seen it before, from the other side. He understood how quickly neutral encounters could be reframed once documentation began. He also understood that challenging the order in that moment would only accelerate the process. So he chose restraint. He stood slowly. He gathered his belongings. He made no sudden movements. He did not raise his voice. His compliance was complete, but it was not an admission. It was a tactical decision made in real time. The officer continued speaking even as the man prepared to leave. He reiterated the order as though repetition alone legitimized it. He did not acknowledge the absence of cause. He did not invite clarification. He maintained control by refusing dialogue. The staff remained silent. Other patrons looked away. The room adjusted itself around the authority being exercised. This is how escalation often occurs, not through force, but through isolation, by removing witnesses from participation, by normalizing compliance, by allowing power to operate without challenge, because challenging it feels disruptive. The officer walked the man toward the exit, not physically, but symbolically. His presence directed the movement. His silence discouraged questions. The imbalance was complete. At no point did the officer ask for identification. At no point did he confirm the man's status. At no point did he document a violation on site. Those omissions would matter later. As the door opened and the man stepped outside, the encounter ended as quietly as it had begun. There was no arrest, no citation, no report filed in the moment. To anyone observing casually, it appeared inconsequential. But the escalation had already occurred, because authority had been exercised without foundation, and discretion had replaced justification. What remained was a record, fragmented, partial, and incomplete. A record that would later be reconstructed not by intent, but by evidence, by what was said, by what was not said, by what was required and never provided. The officer returned to the cafe. The routine resumed. Cups were refilled. Conversations continued. The system appeared intact. But the escalation had triggered review mechanisms the officer could not see. Mechanisms that do not respond to emotion, but to process. That do not consider tone, but compliance with standard. The misuse of authority does not announce itself in the moment. It reveals itself later, when actions are examined without the benefit of assumed discretion. And by then, the narrative is no longer controlled by the person who initiated it. It is controlled by records. What made the encounter legally significant was not the tone of the order, but its foundation. In public accommodations, authority does not operate on instinct alone. It requires articulation, a reason, a condition that justifies intervention. In this case, none was provided. At the time, the absence may have seemed inconsequential. Officers issue directions daily without formal citations. Most encounters end without review. But legality is not determined by frequency. It is determined by threshold. The first threshold is cause. Without a reported disturbance, a request to leave a public business must be supported by a specific justification. Trespass law does not activate automatically. It requires notice from the property owner or evidence of prohibited conduct. Neither existed here. The second threshold is scope. Even when discretion is permitted, it is not unlimited. Authority in public spaces is constrained by purpose. An officer may observe. An officer may inquire. An officer may intervene when conditions are met, but authority cannot be used to manufacture those conditions retroactively. The encounter crossed that line quietly. The man did not refuse to leave. He did not obstruct. He did not argue once the direction became final. From a legal perspective, his conduct removed any claim of exigency. There was no emergency to justify summary action. What remained was the order itself. Later, when the incident was reviewed, the analysis did not begin with motive. It began with sequence. What prompted the contact? What information was gathered? What steps were taken before authority was exercised? Each omission narrowed the officer's defense. The lack of identification request became relevant. Verification is not mandatory in every encounter, but when authority is used to exclude someone from a public space, confirming identity can clarify jurisdictional limits. That opportunity was bypassed. The lack of documentation mattered more. No contemporaneous report meant the narrative would be reconstructed from independent sources. Video, audio, witness statements. The officer's discretion would not be evaluated in isolation, but against an objective timeline assembled later. This is where many misunderstandings occur. Officers are often taught that compliance resolves encounters. Legally, compliance only resolves resistance. It does not cure an improper command. The man's decision to leave did not validate the order. It preserved the record. By choosing not to escalate, he allowed the encounter to stand as it was unchanged by additional variables. There was no arrest to complicate the review, no use of force to distract from the initial decision. The focus remained fixed on the moment authority was asserted. From a legal standpoint, this clarity is rare. When the incident reached review, the questions were narrow. Was there a lawful basis to issue the order? Was that basis articulated? Was the action consistent with policy governing public interactions? The answers did not require speculation. They required comparison. Policy language was examined alongside footage. Training materials were placed next to transcripts. The officer's actions were measured not against intent, but against standard. And standard is unforgiving. Discretion exists to serve law enforcement objectives, not to replace them. When discretion is exercised without reference to objective criteria, it becomes indistinguishable from personal judgment. That distinction carries consequences. By the time legal counsel reviewed the file, the analysis had already crystallized. The encounter did not fail because it escalated. It failed because it bypassed the steps designed to prevent escalation. That failure did not appear dramatic in the moment. It became decisive later, because legality is not determined where authority is asserted. It is determined where authority is reviewed. And review does not consider what felt reasonable at the time. It considers what can be justified afterward. In this case, justification would be difficult. The shift did not happen publicly. There was no announcement, no immediate consequence. It began with preservation. Footage from inside the cafe was secured before it could be overwritten. Audio from nearby cameras was synchronized. Timestamps were aligned. What had seemed like an unremarkable interaction was reduced to data points and frames. The officer's body camera provided only part of the picture. It showed the approach, the order, the repetition. It did not show justification because none was spoken. That absence became visible only when the footage was reviewed alongside policy. Video from the cafe filled in the rest. From multiple angles, the same sequence appeared unchanged. The man was seated. The environment was calm. No staff interaction preceded the contact. No complaint was registered before the order was issued. The officer's attention appeared self-directed. This mattered because evidence does not interpret, it records. Investigators slowed the footage. They replayed the moment the officer decided to engage. They noted what was not said. No request for identification. No inquiry to staff. No explanation of cause. The silence between statements became as important as the statements themselves. Witness accounts aligned without coordination. Patrons described the same tone: calm, controlled, unnecessary. Employees confirmed they had not asked for assistance. Management stated no policy violation had occurred. Individually, none of this would have been decisive. Together, it was conclusive. The man's departure, captured clearly on camera, eliminated any claim of disorderly conduct. He did not argue, he did not delay, he did not provoke. The footage showed compliance without concession. From an evidentiary standpoint, this was ideal. There was no competing narrative, no conflicting behavior, no escalation to reframe the encounter. As the review progressed, the focus narrowed. Investigators no longer asked what might have justified the order. They asked why the order was given at all. That question carried institutional weight. Internal reviewers flagged the encounter for secondary analysis. Training supervisors were consulted. Legal counsel requested full documentation. The incident moved from administrative review into formal evaluation. At that point, discretion was no longer relevant. The evidence dictated the process. What had once been a matter of perception became a matter of record. Each frame reinforced the same conclusion. Authority had been exercised first and explained never. That sequence violated the safeguards designed to prevent exactly this kind of misuse. The officer's statements, made after the fact, were measured against the footage. Where explanations expanded, the record remained fixed. Where intent was claimed, the video remained silent. Evidence does not argue back. It waits. By the time the review reached its final stage, the outcome was no longer uncertain. The documentation had done what emotion never could. It had reversed the balance of power without confrontation. The encounter was no longer about a man asked to leave a coffee shop. It was about an officer who could not demonstrate why. And once that question is asked formally, it cannot be unanswered. The review did not stop with the encounter itself. It widened. Once the footage and witness statements were cataloged, investigators began tracing patterns. Not motives, not intent, patterns. The kind that only appear when individual actions are placed beside prior records. Training files were pulled first. The officer's certification history showed nothing unusual at a glance. Required courses completed. Annual refreshers logged. Policy acknowledgments signed. On paper, compliance appeared intact. Then, complaint records were examined. Individually, none had resulted in discipline. Each had been resolved quietly. Insufficient evidence. No sustained finding. Discretion exercised. The language repeated itself across years, forming a familiar administrative rhythm. What stood out was not severity. It was similarity. Multiple complaints described the same sequence. Public settings. No prior disturbance. Orders issued without explanation. Encounters ending without arrest but leaving lingering questions. Each incident dismissed on its own merits. None escalated beyond internal notation. Until now. Investigators compared timelines. They mapped locations. They noted how often authority was asserted absent a precipitating call or a request from property owners. The pattern was subtle enough to avoid detection when viewed in isolation. It became unmistakable when aggregated. Supervisory oversight was reviewed next. Approval chains revealed a reliance on officer discretion without corroboration. Body camera footage was rarely audited unless force was used. Encounters ending in compliance were assumed resolved. The system rewarded quiet outcomes, not correct ones. This was not a failure of a single decision. It was a failure of verification. The department's review protocols prioritized escalation events, arrests, use of force, formal charges. Encounters that ended without paperwork were effectively invisible. Authority exercised without resistance left no institutional footprint until evidence surfaced externally. Once the cafe footage entered review, prior assumptions collapsed. Investigators could no longer rely on summaries written after the fact. They had raw data, unfiltered, consistent. The question shifted again, not why this officer acted as he did, but how often similar actions went unexamined. How many encounters ended quietly because compliance was mistaken for legality. How many times discretion replaced justification without challenge. Internal emails reflected this shift. Language became cautious. References to policy appeared more frequently. Legal counsel advised expanded scope. The issue was no longer personnel management. It was exposure. Because once a pattern is established, liability multiplies. Civil review panels requested historical comparisons. Training supervisors were asked to explain how public space authority was taught. Command staff were questioned about audit thresholds. Each answer revealed the same structural gap. No mechanism existed to routinely review non-escalated encounters. The system assumed that absence of conflict equaled absence of violation. That assumption had governed oversight for years. It was efficient, it was quiet, and it was flawed. The cafe incident forced that flaw into view. When the man's professional background became known to reviewers, the implications sharpened. Not because of his status, but because of what his training represented. He recognized procedural overreach precisely because he had enforced boundaries himself. His response preserved the record that others might have inadvertently obscured. The system had not failed because it was malicious. It failed because it was incomplete. Oversight mechanisms were reactive, not preventative. They activated after harm, not after misuse. Authority exercised without resistance bypassed scrutiny entirely. By the time the pattern was acknowledged formally, the scope of review had expanded beyond one officer. It included supervisory practices, audit protocols, training emphasis, documentation standards. No one could claim ignorance. The record showed what had been ignored. The system had been operating as designed, and that design carried consequences. What followed would not be resolved internally. The documentation now existed outside departmental control. Once exposed, systemic failures do not retreat quietly. They move forward into litigation. Once the findings were formalized, the matter moved beyond internal correction. Administrative review had identified policy failures. Evidence review had established procedural violations. What remained was liability. The city was notified first. Legal counsel received the compiled record, synchronized footage, witness statements, training materials, prior complaint patterns, and supervisory review notes. The documentation was complete enough that no additional fact-finding was required to assess exposure. The analysis was not emotional. It was arithmetic. Attorneys evaluated the likelihood of prevailing at trial against the cost of settlement. They examined precedent, comparable cases involving public accommodations, federal civil rights standards, jury outcomes where authority had been exercised without lawful basis. The numbers were not favorable. Depositions were scheduled, but narrowly scoped. There was no dispute over what occurred. The questions focused on justification, training, and oversight. Each answer reinforced the same conclusion. The encounter could not be defended on procedural grounds. The officer was placed on administrative leave pending outcome. Certification review followed. Training records were revisited under a different lens. What had once appeared compliant now reflected missed corrective opportunities. Disciplinary action proceeded quietly. Termination was recommended based on policy violation and failure to adhere to public interaction standards. The recommendation was upheld. The officer's employment ended without ceremony. Appeals were limited by the record itself. Evidence left little room for reinterpretation. Parallel to the personnel process, civil negotiations advanced. The city acknowledged responsibility without admission of intent. Settlement language was precise. It referenced findings, not motives, procedures, not character. The agreement emphasized corrective action and compliance reforms. The payment amount was finalized at $4.5 million. The figure reflected more than the single encounter. It accounted for systemic exposure, for the pattern that had been documented, for the oversight gaps that had been confirmed. It represented the cost of failing to intervene earlier. Once approved, the settlement was entered into the public record. There was no press conference announcing victory, no statement assigning blame. The transaction spoke for itself. In addition to financial terms, the agreement mandated policy revisions, audit thresholds were lowered, non-escalated encounters became reviewable, supervisory oversight expanded to include routine public interactions. Training modules were revised to emphasize justification before discretion. These changes were not framed as punishment. They were framed as correction. From a legal standpoint, the outcome was final. The settlement closed the civil claim. Administrative actions concluded personnel review. There were no remaining avenues to contest the findings. The law had completed its work. What remained was precedent. The case entered reference databases. It became a citation in training materials, a benchmark in municipal risk assessment, an example used not to inflame, but to instruct. The consequences were not dramatic in their execution. They were decisive in their effect. Authority had been exercised improperly. The system had failed to catch it early. The cost of that failure was now fixed, documented, and irreversible. After the settlement was finalized, the public attention moved on. There were no sustained protests, no prolonged debate cycles. The story did not persist because of outrage. It persisted because of its implications. Municipal risk assessments were updated quietly. Legal departments circulated internal summaries outlining what had failed and why. The emphasis was consistent. Public authority requires articulated cause, even when encounters end without resistance. Training academies incorporated the case into instruction scenarios, not as an example of misconduct, but as a demonstration of procedural drift. Recruits were shown how easily discretion can replace justification when oversight is reactive, how compliance can obscure violation. Policy language was revised to reflect these lessons. Public space interactions were no longer treated as low risk by default. Documentation thresholds were adjusted. Supervisory review expanded beyond use of force incidents. The system recalibrated itself using the record as reference. For businesses, the case clarified boundaries. Property owners were reminded of their role in initiating trespass enforcement. Law enforcement agencies reinforced the requirement that removal from public accommodations must be grounded in request or violation, not assumption. The settlement also influenced litigation strategy elsewhere. Plaintiffs' counsel cited the case when evaluating similar encounters. Municipalities referenced it when advising early resolution. The financial figure attached to the outcome became a benchmark, shaping negotiation posture long after the facts themselves faded from headlines. The man at the center of the encounter did not seek visibility. He did not tour media outlets. His involvement ended where the law concluded it should at resolution. The system corrected itself through process, not performance. This distinction mattered because the case did not hinge on emotional reaction or public pressure. It turned on documentation, review, and adherence to standard. It demonstrated that accountability can occur without spectacle when records are preserved and procedures are followed. The precedent it left behind was structural, not symbolic. Authority, when exercised in public, must be defensible in private review. Discretion cannot substitute for justification, and compliance does not erase obligation. The law does not respond quickly, but it responds consistently. In this case, that consistency produced a result that extended far beyond a single coffee shop, reshaping policy, recalibrating oversight, and reinforcing a principle that would be cited long after the moment itself was forgotten. That is how accountability endures.